Item 1, WPC 4397/2019.
The writ petition is dismissed.
Wait, Lord, we have filed the IMA, and we have also sought your lordship's leave to file the affidavit.
आइटम नंबर 2 पे बुढ़ा अपना आया आइटम नंबर 2 अपना आया
और दूसरों ने भी
आइटम नंबर 2 अपना आया थी तो नंबर 1
The affidavit to purge of the contempt that has not been filed.
No.
No, Miller, because lordship directed that we should obtain a leave. We have filed it, but once your lordship grants the leave, then it will be placed on record. In the IA, we have made that statement.
Mr. CJ Monta, here you write Mr. Kane Chaudhary, and Mr. Kane, this is IA, and Mr. Kane Chaudhary, and it's in a council, assisted by Mr.
Ujit P. Gayan.
P. Gayan, Learned Counsel. Also heard Mr. TJ Monta, Learned Senior Counsel, and standing counsel for this court. Next. By filing this interlocutory application under Rule 8 within bracket 2 of the contempt of court, contempt of court within bracket Gauhati High Court bracket close rules from 1977. The applicant, who is the respondent in the connected contest within bracket criminal within brackets 2 moto bracket close 1 of 2025, has prayed for leave to file his affidavit and also for grant of bail in the said proceeding. Having heard the learned standing the senior the learned senior counsel and standing counsel for this court, both the prayer made in this interlocutory application stands allowed. The next part, the applicant is granted leave to file his affidavit in the connected contempt petition. Next part, moreover, the applicant is granted bail on condition that he would appear before the registrar within bracket judicial and submit a bond of rupees 10,000, an undertaking to appear on all dates of this proceeding, unless exempted specifically. The applicant is put to notice that in the event he absents himself without exemption being granted, the bond would stand discharged. Subject to orders of the court, the bond is liable to be discharged. Next paragraph. You filed the affidavit within what time?
No, we have already filed it.
Okay, then it will only be brought on record.
Yes,
Okay, the affidavit already filed. Then
So,
brought on-
ওখানে বলো।
Next one.
Oh, no, it's not completion.
Please tell us when we list it again.
according to Lordship's convenience,
Tell
Miller.
us.
Not patient, 13
This March itself, Miller, or it can be on 23rd, Miller.
No,
Oh, sorry, my
23rd,
learned friend have difficult.
23rd.
Have it in the first week of April.
Yeah.
April.
No, my lord, no problem. Okay, no, no, no.
Miller, it should be before 9th, Miller, if it is not 6th, 7th, 8th, any day.
He's taking home on by.
Second April or not?
Miller, 7th.
Second, two.
Yeah, 2nd April, no problem.
Two. 4/26.
Deep level.
That was kind of what I'm going to go by.
Yes, Miller.
You filed any medical documents out here?
Yes, yes, we have filed. In the affidavit, we have annexed everything. Miller.
You want to file any reply?
Let me, I haven't gone through it, if required, I'll file. In the meantime.
Then we leave, then before that you write. The, you shall be brought on record. What's what? The.
Like you are the position of the order you.
The, in conduct between the. Respect each other and any of 44. For this book and respecting and for the levels in it's stated by. A guy.
P guy only.
Also. Next method. By order passed today in the interlocutory application, one of the petitioner has been granted leave to file an affidavit. Instructive. Direction has also been issued to bring on record the affidavit already filed by the respondent. Contempt. Next. Reply, if any, by the
My lord. Devin.
by the court, they will file. It is 3 days prior to the.
My lord.
This is the matter of two. 4/26.
Mr. Chaudhary, is your client still using the social media?
No, Miller. We have advised him not to do.
I hope he gives an undertaking to the effect, taking into account that he is not in census as per you have.
Right, Miller. Yes, yes, enough is enough.
Alia also
Enough is enough. Yes.
Client says you have not seen it.
Not all, that objectionable one, I have seen it, Miller.
No, it earlier.
Not all.
Lordship, petitioner herein relying on the Putna list of 1965, Lordship at page 60. Lordship, where his projected father's and mother's name has been reflected, Lordship, as Ramijuddin Ali and Romena Bibi. At that time, Lordship, Ramijuddin Ali was 75 years of age, Lordship. Projected father.
Just a moment.
Yes, sir.
AHATUN, Hatun. 3807 of 2006. It is a reported case, my lord. It is reported on 2018 4 GLT 373. 18 4 GLT 373. Regarding Gaubra certificate, lordship, paragraph 22. It is tried. Yes, Lordship. Lordship, DW3 deposed here, Lordship. As Zuhura Bibi projected herself as the elder sister of the proceeding, Lordship. But Lordship, one Zuhura Bibi deposed before the tribunal, Lordship. And but in her WS, Lordship, proceeding never disclosed about this person, Lordship, as her elder sister. And Lordship, regarding that, Lordship, our High Court has observed, Lordship, in this respect in 2017 2 GLT 1076. Momin Ali, MOMIN, Momin Ali, versus Union of India. Para 12 is also important, Lordship, regarding written 2017 2 GL 076, repetition number 4698. GLT 1076. Lordship, regarding WS and Lordship, sudden appearance of the person during the time of evidence, Lordship. Momin Ali, MOMIN, Momin Ali. Well, Lordship, para 12 also important, Lordship, I am reading. This written statement of the petitioner was solely inadequate and did not disclose any material facts as noticed above. It was the allegation of the state that the petitioner was a foreigner, therefore, as per mandate of Section 9 of the Foreigners Act 1946, it was the bounden duty of the petitioner to have disclosed all material facts which were specifically within his knowledge in the written statement, but he did not do so. Petitioner neither mentioned his date of birth nor his age. He was silent regarding the name of his mother and identity of his grandparents, both paternal and maternal. He did not mention anything about his brothers and sisters or about his marital status. On the basis of such a written statement, it cannot be said that petitioner had stated anything substantial to show that he was not a foreigner but a citizen of India. It is a settled position of law that where a party fails to set up a case in his pleadings, he would be debarred from adducing evidence in his support at the stage of trial. As a matter of principle, variance between pleadings and proof is not permissible. Again, para 17, I am reading, reverting back to the written statement, it is already been noticed that there was not a whisper by the petitioner that he had any brothers or sisters, not to speak of disclosing their names and their particulars. Therefore, this sudden appearance of Umar Ali in the witness box as brother of the petitioner has to be looked with suspicion, and this suspicion is further forfeited by the fact that in the 1997 voters list, name of Umar Ali did not appear along with the petitioner. That apart, in Exhibit 6, the land document, periodic Khiras Patta, name of Umar Ali did not appear along with the petitioner as Patta holder. Therefore, evidence of Umar Ali was rightly discarded by the tribunal. Here also, Lordship, this person has suddenly appeared, Lordship, DW3, elder sister of the proceedings. And Lordship, although DW Yes, Lordship. And although Abdul Latif Khan's Lordship projected brother of the proceeding Lordship, although his name has been mentioned, this Abdul Latif Khan also failed to establish his link with his projected father, whose name enlisted in the voter list of 1965, Lordship. That's all, Lordship.
My lord, in the written statement, my lord, the petitioner has stated that his, my lord, brother's name has stated, my lord, unfortunately, my lord, the learned engaged counsel, my lord, that has not been, my lord, prepared, my lord, the name of the petitioner's elder sister's name was not appeared in the, my lord, written statement. But, my lord, the brother of the petitioner, who is adduced as DW2, my lord, his name has been appeared in the written statement, my lord. And my lord, in the, but in my lord, DW2, kindly see, my lord. DW2, my lord, at the time of cross-examination, my lord, page 39, my lord, page 39. My name is Abdul Latif. My father's name is late Ramizuddin Ali. My father expired about 40 years back. I resided village Goraimari. Earlier, I was residing at village Belbari. During agitation in 1983, we shifted from Belbari to Goraimari. Shonabhanu is my own sister. Second party is residing at village Sengelia. Second party's husband's name is Quddus Ali. My mother also expired about 30 years back. I have no dwelling house of my own. My mother's name is Romena Bibi. Romena Bibi is the second wife of my father. I have no brother. I have 3 sisters. That is, my lord, I have 3 sisters. Remaining 2 are Johura and Rohila Bibi. That is, my lord, from her side, from the Romina Bibi, there is second wife, my lord, of the father of the petitioner, my lord. From Romana Bibi's side, my lord. There, my lord, one brother and three sisters, including the petitioner, my lord. That is, my lord, brother is Abdul Latif, my lord, and sisters are, my lord, that is Johura and Rohila Bibi, and my lord, the Shunavhanu, my lord. And thereafter, my lord, in DW, the cross of, my lord, DW1, cross of DW1, my lord, that is page 32, my lord. Page 32. My father's name is, my name is Shunabhanu. My father's name is late Ramizuddin Ali. My father expired about 40 years back, my lord. That is stated, my lord, as same by the, my lord, DW2, my lord, the elder brother. My mother also expired about 30 years back, my lord. That is, my lord, version is, my lord, similar. I have one brother, namely Abdul Latif Khan. I was born at village Belbari. I got married at Sengulia. My husband's name is Quddus Ali. In the voter list of 1990, my name appeared as Mehra Khatun, and that name was given by my husband. But in the voter list of 1997, my name has recorded as Shuna Bhanu. That is, my lord, same thing, my lord, page 47, DW3, my lord, DW3, page 47, cross of DW3, my lord. That my name is Johura Bibi. My father's name is late Ramizuddin Ali. I am resident of village Karagari Nonke, block 12, at Mauza Shorokhetri, police station, Sathebari, district Borpeta. Pro court. My name is Johura Bibi. My husband name is Jalal. Is my own sister. My, about 40 years back. There's similar person, my lord, and about 30 years back. I have one brother, namely Latif. I have casted in 1966 for the first time. Malika Bibi. And there is my DW4, my lord. That is my cross part. My name is Quddus Ali. That is page 53, my lord. Page 53, my lord. My name is Quddus Ali. In the, my lord, first part of DW4, my lord, at page 53, my lord, the husband of the petitioner also stated, my lord, the brother's name and other sister's name, wherein the that my name is Quddus Ali, my age is 60 years, father's name is late Adu Devan. Today I have appeared to adduce as witness for Shuna Bhanu. Second party is my wife. Second party was born at Belbari Patha, age 50 years. Second party's father's name is Romiz Uddin. I do not know the mother's name of second party. Shuna Bhanu are three sisters, my lord. Yes, my lord. My lord, at least there would have some, my lord, doubt, the region of doubt, my lord. But in this present case, my lord, there is no any region of doubt regarding.
4. Item 4.
Item C. Intent final order number is 18 to 23 mellow, is 18 mellow, can you see? Mr. Chihan Ahmed will also put the picture. And it's also for the response. The 18, opinion date is 27/11/2025.
Item 5.
Pursuit matter may be passed over for the timing.
Right, please, Josh. Malat, I am agreed by an expertise order, you know.
Item 6. affidavit to the
In
petition.
your writ petition,
Yes,
here you have not stated that he has died. Correct? Now, if you come to page uh, your written statement at page 14, paragraph 5,
my lord.
your father is said to be late Jawhar Ali. But the date of death is not given.
Here is written, yes, that is late.
There lies the difficulty. You're disconnected with your father.
Only that is a father and mother, whether they have not father not deposed in the
No,
court.
because if your father had landed property, on his death, it will devolve on you. But you're not producing
But
any.
that is not automatic problem, you know, the admission process is there.
No. Nobody will leave a land like that. Unless he is filthily rich. That plot of land doesn't matter to him, only then. But you say you are poor.
But on that point, Milapur, I have no clear instruction. So, Milapur, your lordship,
Sorry.
yes,
Continue post lunch.
Item 10,
Yeah, please, Lordship. So impugn order plus 99, my lord. The contested is not, my lord.
Page number
Plus 99,
39.
Lordship. By the order date 27/2/2023, my lord.
What is the page number?
Plus 99, Lordship.
99.
Lordship.
But Mr. A. Mubarak, learned counsel for the petitioner and so for the respondents. Page 99, opinion dated 27/2/2023. Passed by so in case number so. Thereby declaring the petitioner to be a foreigner of post 25 in 1971 scheme. Notice returnable on so. Extra copies within 2 days, call for the records. Same prayer for bail shall be considered receipt of tribunal's records. In the meanwhile, if the petitioner, namely so and so, is apprehended, and she shall not be deported out of the country without order of the court. This is a cost. Production of a certified copy of the order before the Superintendent of Police, Border, Nagaon,
Nagaon.
list on so and so.
22nd April.
It will not inordinate delay now. Okay.
Masud.
Item 11,
In receipt of the tribunal's records. Opinion is at page 101, dated 18/6/2024. Passed by so and so in case number so and so, police reference number so and so. Thereby declaring the petitioner to be a foreigner of post 25. Same date. Produce a certified copy of the order before the SP. Border,
Border Sonitpur, Your Worship.
Sonitpur.
Obliged, Your Worship.
item 12,
Yeah, please, Your Lordship.
Your next party order dated 24/1/2024.
Okay, right, Mr.
F.A. Ahmed.
F.A. Ahmed.
F.A.
S.A. Ahmed. Learned counsel for the petitioner. And so for the respondent. Ex parte opinion dated 24/1/2024, page 52. Passed by so and so in case number so and so, police inquiry number so and so. In this case, Mr. Sharma, is it required to call for the records? Look at paragraph 2. Page 52.
Yes, Doctor.
Not yet.
Send it back. Yeah, allow your page 52, opinion dated 22. Next paragraph. The learned counsel for the petitioner has submitted that it would be evident from paragraph 2 of the impugned opinion dated 24, ex parte opinion dated 24/1/2024, that the notice was served by hanging on the wall of the Gaon Panchayat office. Full stop. Next paragraph. No, not next paragraph, continue. Accordingly, it is submitted that the notice was not served in accordance with order 3.
P5F.
G. Yes,
It's it.
yes, the foreigners within bracket tribunals, bracket close order, 1954. Next paragraph. The per quarter, the learned standing counsel for the FP and border matters has submitted that there was no infirmity in the acceptance of the process on the ground that the petitioner had left the place of residence without informing any government official. Accordingly, as the petitioner could not be located, the notice was duly served in the office of the Gaon Panchayat. Next paragraph. The court is inclined to take notice of the fact that hanging of a notice in the wall of the Gaon Panchayat office is not the manner prescribed under section 3, order 3.5 within bracket small g. Let the G will be said. And oblique under order 3.5 F of the foreigners within bracket tribunals, bracket closed order, 1964. Accordingly, the court is inclined to hold that the manner of service of notice on the petitioner, having not been made in accordance with any of the provisions under order 3 of the under order 3 within bracket 5 of the foreigners within bracket tribunals, bracket closed order, 1964. The manner of service of notice is found to have vitiated the impugned ex parte opinion. Next paragraph. Accordingly, court has no hesitation to set aside the impugned ex parte opinion dated 24/1/2022, page 52. Next paragraph. The petitioner is directed, the petitioner, who is duly represented before this court through her learned counsel, is directed to appear before the learned member, foreigners tribunal, Jorhat. Positively on or before 8th April 2026, and by producing a certified copy of the order, shall also file a written statement. Next paragraph. The learned tribunal shall make an endeavor to complete the proceedings in, as far as practicable in light of the provisions of
314.
order 3 within bracket 14.
Yes.
Right.
Yes, Lord.
314 of the ordinance within bracket tribunals, those rules from 1964. So date of appearance is 8th of April. You file your written statement on that day. Writ petition stands allowed at the motion stage without issuance or notice on the respondents.
Item 13.
May I please, Your Lordship? My lord, the impugned order is at page 129.
When Shakespeare say et tu Brutus,
My lord,
Shakespeare said what? Et tu Brutus. Page number?
129, my lord.
Right. Mr. P. Prasad, then counsel for the petitioner and so also for the respondents. Opinion is at page 129. Dated 3/1/2023. Passed by so and so in FP case number so and so. IMDT case number so and so. That is the petitioner was declared to be a foreigner post 25 in 1971. Notice returnable on so and so. Extra copies have been included all for the records. Declared for bail shall be considered on executive favorable records. Next para, in the meantime, if the petitioner named so and so is apprehended, he shall not be deported out of the country without order of the court. The petitioner shall cause production of a certified copy of the order before the Deputy Commissioner of Police.
Dobry.
No, you are wrong.
DCP border. Kamrup Metro.
Kamrup Metro, the case is here. I'm permanent resident on Dobry.
No, he will not give you bail.
My lord.
Then you'll have to amend your petition. You have to impeach the appropriate party.
My lord.
Then you'll have to file an IA then. Then you have to
Fine.
file an IA. Don't get this. So. Chief Prasad, then counsel to the petitioner. Let's see. Both sides are represented. The notice of the on notice being drawn to the learned counsel for the petitioner, he pays for some time to file an interlocutory application for amending the cost title for substitution of respondent numbers 5 and 6. With the appropriate person, as the reference was made by the then Superintendent of Police within bracket border, that it was city, Gauhati. That's for that. Accordingly, the matter stands adjourned today. This, as in the interlocutory application, is fine.
Public.
Item 14 for motion.
May I please your lordships? In this matter, lordship, the petitioners are the legal heirs of the proceeding lordship who expired lordship prior to the initiation of the proceeding lordship. The petitioners number 1 is the wife and petitioner number 2, 3, 4 are the son of the deceased proceeding. The order whereby the proceeding was declared foreigner is at page 100 laws. His name is Ali Asghar Ahmed.
Certificate of page 66.
Lordship.
You're relying on a death certificate of page 66.
Yes, I have the death certificate also. Lordship.
There is notice then.
Lordship. Yeah. Here, the proceeding lordship died on 23/2018 lordship. And subsequent
No,
to
no,
that,
that must, you must understand when you are pointing out the document, we have read it, that means.
Yeah.
Is it not?
lordship.
Okay, we are issuing notice. Third, this is the answer for the petitioner and also for the respondent. There is the opinion, page
Oh, 100 loss,
100.
100 loss, 100 loss. Ex parte order.
The petitioners project themselves to be the legal representatives of Ali Asghar Ahmed, ALI-AJGOR Ahmed, who, against whom proceedings was initiated before the learned member, foreigners tribunal number 5th, Dhubri, which was Dhubri full stop. In the ex parte opinion dated 7/10/2021, the learned member, foreigners tribunal number 5th, page 100. Arising of so-and-so, declared the said proceeding to be a foreigner was entered into Assam, public India illegally after 25/9/71 from the specified territory. Next para. By referring to the deaths, photocopy of the death certificate, which is annexed as annexure 15 to the writ petition, it is submitted that the said proceedee, namely Ali Asghar Ahmed, had died on 20/3/2018, and his death was registered with the registrar of births and deaths, Dumardaha, DUMARDAHA, MPHC, and a certificate bearing registration number 38/2018, dated 2/4/2018 was issued. Next, but accordingly, it is submitted that as the petitioners would be adversely affected by the said impugned ex parte opinion, the present date petition has been filed to assail the said ex parte opinion dated 7/10/2021. Next, issue notice, returnable constituency. Extra copies in 2 days, call for the records. Next, list also and so forth. Give extra copies.
Loss. Lordship, I have a prayer for interim for stay of operation because.
There can be a state. You're not the affected person.
No.
And the law is that once there is a reference against you, only then you can be
Obliged, Lordship.
Item 15.
My pleasure, Lordship, opinion is at page number 55. Opinion is dated 27/11/25.
Page number?
Page number 55.
But Mr. J. Siddhal and the petitioner and so and so for the respondent. Opinion dated 27/11/2025, page 55. Asked by so and so in case number so and so, police reference number so and so, thereby declaring the petitioner to be a person of 1971. Notice retortable on so and so, extra copies is included, is called for the record. Next matter, the prayer for bail is opposed by the standing counsel for the FT and border matters. Power, comma. Considering the projection made in this petition, comma. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Morigaon. Sit here. You're now taking a plea after so many years in Para 9 that the advocate made a mistake in the written statement. Okay, next.
Item 16 for motion.
Please, Your Lordship. My lord, impugned order at page 106.
One,
106, Lordship.
6.
Yes.
So am I Hussain by the property commissioner and so for the respondent? It is page 106, dated 17/12/2025. Asked by so and so, in case number so and so, reference IMDT number so and so. Thereby declaring the petitioner to be a foreigner of 4.5 state. Notice returned within 4 weeks. Extra copies within 2 days. Also the record. Prayer for bail is opposed by the understanding of the FP matters. Constantly positive. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border.
Borpeta.
Forfeiter. This was also. These are the 4 weeks.
Deeply obliged.
Supplementary item 39 for motion. Upgraded item 35 for orders.
Just wait, we have left out item 33, we are calling that. Just wait. first one. Item 33.
Item 33.
Will be taken after some time, not like.
After some,
Unit is on regular.
Okay. After some time. 34, there was a prayer for adjournment made. Mrs. Chaudhary,
Yes, Doctor.
don't the matter. Okay, both sides are represented on the prayer made by Mrs. R. Chaudhary. Matters to the adjourned today, based on 27, 3/2026. Item 35.
35.
May I plead your lordship, an application praying for leave petition and leave appeal, my lord. And under the order dated, my lord, 11/4/2013, my lord. The petitioner challenges these orders, my lord.
কপি স্যার করা নাই নাকি? আমার নাম তো ই করা নাই যে।
Ms. Vasudha,
My lord.
next time onwards, always annex relevant documents here. Because we can't even open up this writ appeal.
Yes.
You have filed a leave application,
My lord.
contain everything. But we are not supposed to open up the appeal. You have paid for leave to file this appeal. Can we open and look into it? Without leave being granted. This has to be all encompassing. You can't avoid. Which page is the impugned opinion, which you are challenging?
Challenging this order dated 11/4/2013 in WPC number 256/2013, my lord.
Page 8.
My lord, that order I have not erased in this leave petition, my lord.
Obviously, we can't give you leave, because we rejected them.
That case, my lord, rejected by this single judge, my lord, and present petitioners, my lord, her
No,
case is,
unless we see what the order is, we can't give you leave.
yes, my lord.
I think of the page 22
But
of the writ appeal. Page 22 of the writ appeal, Lordship. And I think, Lordship, petitioner has no locus to file this writ appeal.
Page 22.
my
Yes,
lord.
Lordship.
Which part of the order you are agreed with?
That order, my lord. Petitioners came this, my lord, jurisdiction of the civil court, my lord. That was barred by the.
You want the civil court to decide citizenship.
No, my lord, yes, my lord. But that orders, my lord, that is barred, my lord. With this applicant, my lord,
So now what you want? You want to pray for a degree of citizenship in the civil court.
my lord,
How will they decide the issue?
my lord,
Who will be the plaintiff in that suit?
my lord, petitioner, my lord, petitioner, she is an Indian citizen, my lord. Honorable
You
citizen of
understand,
India on all
Who
documents.
who are you proposing to be plaintiff in the suit?
And my lord, petitioner, she is before this higher authority, my lord, she is not approached, my lord. And that case is, my lord, decided by the single judge
Yeah,
only,
that's why I'm trying to understand,
my lord.
what is your case? Who is the petitioner? Is the petitioner proceeding in any of the proceedings?
That case not, my lord. There's a computer, my lord, the petitioner challenging that orders, my lord. That's why I am praying for appeal, leave petition, my lord. And delay of furtherance I also filed, my lord.
Tell us. Please tell us what is your case. And how can on what ground you propose to go to the civil court? What will be the structure of your plaint? What would be the nature of prayer to be made in the civil court? Tell us.
My lord, second petitioner case is, I'm saying the first, my lord. Second petitioner case is rejected by this honorable court, my lord. And now, my lord, petitioner, yes,
See, we are wanting to, we desire to ask you a question
my lord.
because we want to upgrade ourselves, our legal knowledge. That's why we are asking you. Since we don't know what would be the nature of plaint, we don't know what would be the nature of prayer to be made in the plaint. Please tell us, how do you propose to make a prayer in the plaint?
My lord, and now, my lord, I'm setting, setting aside this order, my lord, 11/4/2013, my lord.
But what will be the effect of the order if we allow you to file an appeal? Let us assume for the time being that we have not only given you leave, you will also deem that we have allowed the appeal. Order of the learned single judge goes. Now it gives you liberty to file a civil suit. Now please tell us what would be your prayer in the civil suit?
My lord, civil suit is, my lord, petitioner, she is approached this court, my lord, for declaration for citizenship, my lord. All,
So therefore, this will apply in all cases. Supposing there is a case before the election tribunal, you lose that case, you will come to the civil court, declare yourself to be an elected candidate. Some criminal court will punish you for some offense. Go to the civil court and declare yourself to be not a criminal. Can that be permitted? Can the orders of the foreigners tribunal asking you, what do you propose to? You see, you must have a plan. In this application, somewhere you have written that the petitioner went to a lawyer. Lawyer gave him advice. And that lawyer is before us. So now we are asking you on what basis you gave that advice. How would you draft today? You have to draft a plaint. Tell me what would be the prayer?
yes, my lord.
Not
My
very
prayer-
difficult question. I'll tell you what would be the prayer. The prayer would be to declare the opinion passed by so and so tribunal to be illegal. Correct. Then you say, then give a declaration that I am a citizen of India. Now, can an order of the tribunal be challenged successfully challenged before the civil court? We are questioning the very wisdom of the case of L. Chandra Kumar. application bench judgment. You're challenging the very wisdom of that decision. You've read L. Chandra Kumar, definitely. You do service matters also. And what is the division bench doing here? Two judges are determining challenge against the orders of the tribunal, and you want to go to civil court. They are also questioning our wisdom, collective wisdom. They're also challenging the collective wisdom of the Supreme Court, which has ordered that henceforth the orders of the tribunal will be challenged in the High Court. Sorry, we are dismissing it. This can't be good. But this visible and also for the applicant. Also heard. So also for the respondents. That's right. In brief, comma, the case of the applicant is that she had received a notice of the proceedings from the foreigners tribunal, Lanka, suspecting her to be a foreigner of post 1971 stream. The said case, which arose out of FD H 402 2014, was registered as FT L 288 15. The applicant filed a written statement and also adduced her evidence. However, the said learned tribunal, by an order dated, by an opinion dated 22/2017, declared the applicant to be a foreigner of post 1971 stream, illegally and without valid and lawful ground. The said opinion challenged by the applicant before this court by filing a writ petition which was registered and numbered as WBC number 2340 of 2017. The division bench of this court by judgment and order dated 9/12/2025 dismissed the writ petition without interfering with the opinion dated 22/2/2017. Stop. Next paragraph. In paragraph 2 of the writ petition of this lead petition, it has been stated that against the said order dated 9/12/2025, by which WPC 2340 of 2017 was dismissed, the applicant intends to file a civil suit for declaration that she is a bona fide citizen of India. Full stop. It is further stated that it has been learned that by an order dated 11/4/2013, passed by the learned single judge in WPC 256 of 2013, the jurisdiction of civil court has been barred, for which the applicant is unable to file the civil suit. So it is further stated that the applicant came to know about this said order only on 13/12/2025, and she consulted her lawyer and decided to file this at the connected appeal. Next paragraph. The what is proposed by this interlocutory application is preposterous in view of the fact that the learned foreigners tribunal had passed an opinion on 22/2017, which came to be challenged in a writ petition, which were dismissed by the division bench by an order dated 9/12/2025. And the applicant proposes to annul both the orders apparently lawfully passed within the scope of the Foreigners Act of 1946, as well as by this court in exercise of jurisdiction under Article 226 of the Constitution of India, by way of a civil suit. To stop. The next one. The Foreigners Tribunal in the state of Assam have been lawfully constituted in consonance with the foreigners within bracket tribunals, bracket was order from 1964. Would stop. The Supreme Court of India, in the case of Sarvanand Sonwal versus Union of India, in one or two, that it is lawfully proceedings are lawful. Is in Sarvanand Sonwal 2.
One, Lordship.
One.
No.
That the proceedings are Proceedings are lawful. There's an observation that the procedure, that the proceedings are lawful. The procedure is upheld by the Supreme Court. One or two. It's actually. Has declared the procedure prescribed and followed before the coroner's tribunal are lawful and in accordance with law. Therefore, it is wholly impermissible for the applicant to be allowed leave to file an appeal against the judgment and order dated 11/4/2013 passed by the learned single judge in WPC 256 of 2013. In the backdrop of the fact that the orders, that the opinion dated 22/2/2017 passed by the learned coroner's tribunal had already been assailed by the applicant before this court by filing WBC 2340 of 2017, which was dismissed in Division 1 and 1 of the order dated 9/12/25. Next, please. Therefore, the filing of this interlocutory application is a mere abuse of the process of law and a total wastage of the valuable time of this court. Therefore, not only the court proposes to dismiss this interlocutory application, but the court is also inclined to impose cost of rupees 25,000 on the applicants by providing that the said cost shall be deposited before the registry of this court within a period of 1 month from the date of this order, failing which the registry shall take necessary steps for realization of the said cost in such appropriate manner as they will be so advised. This is some of the. Then you say that there's another beginning of the list. Next part. By filing this interlocutory application, that's when so. The application under section 5 of the Litigation Act. The applicant aspirate for controlling the delay of 4619 days beyond the period of limitation in filing the collected fee. Stop. The learned standing on the learned CC command. The departmental counsel have vehemently opposed the clearly from this interlocutory application for condoning of delay. Next part. Seeing the nature of issue raised, though the expression for delay of 4619 days is not found satisfactory, for elder versus the fair made in this interlocutory application is allowed. The said delay is hereby performed So this application stands allowed and disposed of. So we are allowing this application. Second case, we are dismissing cost of 25,000 to be paid within 1 month.
My lord, cost may be, minimum cost may be, my lord. that is for-
We propose.
My lord, that is first time, my lord. My
Not
lord,
first time,
Proposing
Lord.
to increase it. We should have started with 2 lakh rupees.
Penal petition has been continuous.
We should have started with 2 lakh rupees. 25,000 is too meager. On the face of this court, you are telling us that we want to challenge your order before the civil court. 25,000 is nothing. We should have started with 2 lakh rupees. Next.
oblige, your lord.
Upgraded item 37 for orders.
Please, Lord, please. My lord, this interlocutory application has been filed, my lord, for implement of the, my lord, Deputy Commissioner of Police Border, my lord, Kamrup Metro, my lord. Earlier, my lord, it was inadvertently, my lord, left out, my lord. My lord, my lord. Yes, sir. Yes, Lord.
পিসটা কিন্তু তারে আর ওটেন তারে এখানে হয় মানে ওই সিস্টেম সমাধান হয় না কিছু
পিছত proceed হ'ব।
My lord. First time, my lord.
এইটো মোৰ লগত নাই ন।
নাম দিয়া নাই মানে?
Lordship.
My lord, there is a two am hoc, my lord. Actually, ASOC was there, my lord. My lord, yes, I am sorry, my lord. Am hoc twice, it was shown in the am hoc twice, my lord. ASOC, my lord, sorry, my lord. कोई विश्वत नाम पे am hoc पे
প্ৰব্লেম হ'ব কিন্তু। প্ৰব্লেম হ'ব।
করে দিচ্ছি করে দিন করে দিচ্ছি আগতে এখন দিতে
District Commissioner, Lordship, Dorong should also be amended, I think, Lord. Respondent number 5. Reference to your no case book. It could be there, because who has to do it? You know, कोई भी लेकर. नहीं. Public.
Upgraded item 38.
May I please, Lordship? My lord, in this case also, my lord, in IA, page 11, my lord. Inadvertently, my lord, in place of Baksha, it is written, my lord, Nalbari. Page 11, para 8, my lord, second line, my lord. My lord.
In paragraph 8 of the order dated 18/8/2025, passed in WPC 4643 of 2025. Next, it is submitted that in paragraph 2 of the said order, reference is made to the in the cost item. The it should be Baksa.
Yes, my lord.
No, but then you'll have to again.
My lord,
your-
it is, my lord, petitioner from Borpada district is referred in the district of Baksha. And in the judgment opinion also, it is directed to Superintendent of Police Border Baksha. But petitioner from Borpada district. And in the
No.
in the impugned opinion, my
No,
lord.
you see why it has happened is the reason is in your writ petition,
Yes, my lord.
you have read Superintendent of Police Border Borpeta,
Yes, my lord.
District Commissioner Borpeta.
Yes, my lord.
But then Borpeta cannot be made by Baksa without there being implemented.
My lord, in my writ petition, my lord, it is the impugned opinion where the Union of India represented by the Superintendent of Police Border Nalbari. Reference started from Nalbari district, my lords. Subsequently, trial in the Baksha district, and during trial, the district was and here also, my lord, address of the petitioner is Borpata district. Yes, my lord.
No, if you see, we depend on you. If you say Baksa, then in the cost title, you have to amend this because the record would have gone. If the matter is pending before Baksa,
My lord.
the district, the Superintendent of Police Borpeta will not have the record. You have implemented as respondent of 5 Borpeta,
Yes, my lord.
and you want to take bail in Baksa. That cannot happen.
My
I
lord,
made a mistake in the order. But Borpeta was written as Nalbari.
my lord, last page of my writ petition, my lord, the page 109, my lord, in the last
No, no,
line.
We are not disputing
Yes.
what you are saying.
Yes, my lord.
But if it is to be taken by Deputy Commissioner Baksa,
Yes, ma'am.
then he has to be a party here in this. If you think that Borpeta should also remain, you let it remain. But then you'll have to impede as 7 and 8. The Superintendent of Police Border Baksa
Yes, ma'am.
and the District Commissioner Baksa. Then this order can be passed.
I will implement my lord to another as it.
Correction of the order. Substitute transfer as well. Substitute. Superintendent of Police Border Nalbari to Superintendent of Police Border Baksa. Next paper. We notice from the cause title of this interlocutory application and the connected writ petition that the parties arrayed as 1, 5 and 6 respectively are the Superintendent of Police Border Borpeta and the District Commissioner Borpeta. Therefore, in the considered opinion of the court, if the authority before which the petitioner is required, the applicant is required to take bail is Superintendent of Police Border Baksa, then the said authority and the jurisdictional district commissioner are also required to be arrayed as party respondents. Next paragraph, the learned counsel for the applicant is that this is that this interlocutory application be kept pending and he be given liberty to file an interlocutory application for amendment of the cause title. So prayer is allowed. This interlocutory application is adjourned. Most of the petitioner shall, the applicant shall do the input for amendment of the cause title. List as and when the interlocutory application is filed. You're keeping that pending.
My lord. My lord, may I allow to file amended?
We've given you that liberty.
My lord.
We've given you the liberty.
Obliged.
That's why we are keeping it pending. We don't want you to make multiple applications.
Obliged.
Time being item 33, upgraded for orders.
What are the instructions?
No, affidavit, Lordship has directed to file affidavit, that we have filed.
You file.
We have filed.
When?
Delivered.
When?
2/3/26.
On second of.
Second. You want to file a reply?
No, yes,
Not required. You are ready for the hearing?
not today.
Not today. Okay. The process is represented. The chair make well and counsel the applicant will go today. List on when?
Next week, any date.
On 12.
You very barabar. Are you?
12 o'clock. 12 o'clock. 12 o'clock. 12 o'clock.
Okay. List of 12/3/2026.
Comments.
Part third item, supplementary item 41, upgraded.
Okay, just a moment. Mr. Sharma is here or not? You got that observation of Supreme Court in Sarvan and Solvar? Which is that paragraph? I will provide you any time. I will provide. Okay. So Sharma, words are right that the proceedings are just and fair. Yes. That line is one. Oh, acha. We got that. Sharma is there? No. We located that paragraph. So we got it. That is in paragraph. Uh, that is in both the
Yes, Lord.
both Sarvan and Sonwar.
Yes.
Section 9
One and
regarding
both-
burden of
both the
proof is
cases.
basically correct. We got that.
Right. Lordship, para 73 in one, Sarvananda Kunal one,
70.
para 73. Para 73 in Sarvananda Kunal one, Lordship.
One.
Yes, Lordship. 2005 5 SCC 665.
In the second, Supreme is para 43.
Yes. Yes, Lord.
Here it is 48 onwards, Supreme SCC is 48 onwards. 48 to 50.
Yes.
One. 48 to 51.
Yes,
In
Lord.
in the second one.
Yes, 51
Yes.
is put, para 73 is put.
Okay. Yes. Yes.
Lord. My lord, yesterday, Lordship, I have taken my lord to the representation filed by the petitioner at annexure 8, annexure 3, my lord, page 28. My lord, yes,
You were last referring to the complaint case registered as 507 or 25. That is where you stopped.
no, yes, my lord, that is, my lord, I submitted that FRs have been submitted. They raised objection and now complaint case has been registered. Lordship, referring to the representation, my lord, I'll just for a moment, my lord.
Just a moment. To other members of the bar, we may not be able to take up any other matters. This is going to take some time. Yes.
My lord. My lord, kindly, my lord, come to the repetition again for a moment. Page 28 of the representation is a translated copy. For a moment, kindly come to the vernacular one. Just I want to show one aspect, my lord.
Page number.
Page number 31, the vernacular copy of the representation starts. Two aspects, Lordship, may kindly take note in my respectful submission that whatever now they have alleged, these are no allegation of such is available in the representation, nor in the repetition filed in the before the honorable court. This was filed in the month of December 2012. Well, please take note of 33, page number 33. Just indicating, well, they are the persons.
You can go, we'll call you.
They are the persons, well, they have signed the representation. Yeah, Lordship. Number one, মৃত আজিজুর রহমানের মাতা এবং স্ত্রী পুত্র কন্যাগণ, all the family members of the victim. Then kindly see serial number. Lot of persons locally from the localities are there. Serial number 9, Mohibur Rahman. Mohibur Rahman has also signed. And in fact, serial number 15, Kalainer Am Janata. All the people of that area. What I am trying to place before your lordship is that
We are not getting it. Please repeat again.
Malala.
You are referring to this name for what reason?
Lordship. Malala, I am making my submission, Malala, to indicate that in the representation at the time of filing of the representation or the repetition, they have not alleged that one Mongolian-like police, he has given a jerk at his neck of the victim and he died. That was not the pleaded case in the repetition.
You
Nor
are
in the
referring to which of the parties you named to be?
yes, yes. Malala. So in the representation also there is nothing, and the representation was signed by many persons, Malala.
Yes. 15 persons.
All the 15 persons, 15. The first is Malala Azizur Rahmaner Mata এবং স্ত্রী পুত্র কন্যাগণ, all the family members of Malala them, and serial number 9, Mohibur Rahman. I am indicating Mohibur Rahman because Mohibur
Just a
Rahman.
moment. You are saying 1 to 8 are the family members.
No. One are family member. Second is Namanuddin Papadar. He is a villager. 3, 4, 5, 6, 7, 8, all are villagers now. Particularly, I am indicating serial number 9. He is Mohibur Rahman. Mohibur Rahman is one of the person whom they are now trying to rely on his statement and say that he was an eyewitness while the police officer concerned gave physical assault on the victim. What I am trying to submit before your lordship is that Mohibur Rahman is a signatory of this. Even he has not also stated that I have seen that something of that I have seen. At page 32, the incident they have described. Logic. In the additional affidavit, now they have brought a new thing. So that is why my respectful submission is that nobody has stated that particular fact or the allegation is there, that the officer concerned has given an injury, inflicted injury, and they saw. That is not there. That is what I am indicating, and this representation was not filed by one person, the petitioner. It was filed by all the people of the area. Serial number 15, Kalainer Am Janata, all of them, and they said after signature, they said they are all witness. They said that these are all witnesses of that incident, but nothing has been stated, and they said that যেহেতু বিনা দোষে রাজনৈতিক প্ররোচনায় কাছাড় জেলার পুলিশ প্রশাসন জেলা উপায়ুক্ত উপযুক্ত তদন্ত না করে কেন আজিজুলকে হত্যা করা হয়. Their allegation is that why he was killed, nobody is going to inquire. Therefore, they have requested in the next page, they have requested that you just make an inquiry into the incident, but no sort of those the allegation that some jerk has been given and the neck has been twisted. Those are not there. Those are afterthought. Kindly see the next page. What they are basically aggrieved is that that particular police post should not be located there. It should be shifted somewhere else. That is there ultimately in page 34. They have indicated in vernacular. The SP's affidavit I have indicated, paragraph number 5, we have said why the petitioner, the police went to the house of the victim on that day. Kindly, I'll not read, lordship, kindly take note of para 5 of the affidavit, page 40. And specifically in paragraph 7 of that affidavit, at page 43, you have said that there was no external injury on the body of the person. At page 40 and page 43, those are the two paragraphs in the affidavit. There is no external injury. Paragraph 7. Paragraph 5, page 40.
Yes.
We have said that in paragraph 5, page 40, we have said that in connection with investigation of 3 cases, the police, in connection with that, police went to their house and ultimately Ajizur was taken to the police station. And in paragraph 7 in the affidavit we have said that there was no external injury at page 40, at page 42. 43 is the relevant one. Last sentence, page 42, the police surgeon furnished the provisional postmortem report with his finding that no external injury detected on the body of the deceased. No injury was seen. Then the final FSL report came and the final report of postmortem, it was submitted. In fact, lordship, in the affidavit filed by them, filed by the petitioner, some page number 99 is the affidavit. It is the additional affidavit filed by the petitioner.
Just a moment. Yes.
By filing additional affidavit, now my lord, the further allegation has been brought against the respondents. Page number 99 is the affidavit, additional affidavit filed by the petitioner. My lord, paragraph 3 of the affidavit at page 100. It is stated, my lord, that after the custodial death of victim, a magisterial level inquiry was conducted, annexure 2 to the of the petition, wherein a public hearing was conducted in which eyewitness clearly stated.
Just take rest for 2 minutes. For some reason, I have not been able to concentrate. I'm missing your. Just give it 2 minutes. Your submissions are just not registering. Your submissions are not just not registering. Give me 2 minutes.
But we'll wait for something. Touch it. Touch it. Mother, yes. Well, in this matter, Lordship, I have to take up your Lordship to the writ petition and the affidavits filed by them. And I have some case law. Well, may not be possible today, my lord, for to conclude. Correct. So both of us, my lord, we have to just discuss that if Lordship kindly allows us on Monday at 2, we'll go on. Or Tuesday at 2. Tuesday, my lord. Lordship. Wednesday, not. Lot. That's true. That's Malan. But because this matter, I have seen the order sheets. This matter ultimately taken time for service of notice on response number 6. He was not here. He went to Gangtok. Then he come back with no sub notice. That's true. True. So finally, we got the person in the headquarter, police headquarter. Logic. Malad, yes. One of the response number 6 has also filed the affidavit now. But he has prayed for inquiry by CBI into the incident on 7/7/2012. The father of the petitioners allegation is that he was taken by police to the police station at around 12:30 at night, and after that they heard that he died. He was taken to hospital and he was declared dead. So therefore, they have said that various doubts have been raised by them, and ultimately they prayed for inquiry by CBI, NIA, and the PP against the police officer. And the death certificate and postmortem report were not provided to them. They have prayed for providing them the death certificate and the postmortem report, then adequate compensation. These are their prayers. But with these prayers, when they approach the Honorable Court, I have read the paragraphs. Para 4 to indicate what their case is. Para 4, 6, 7, 9, and 13. They projected before the Honorable Court that police mercilessly beaten up the person at night. Paragraph 4, they said that at around 12:30 on 7/7/2012, police surrounded the residence of the innocent Azizur Rahman, father of the petitioner, who was sleeping peacefully at that time. The police, led by YC Gatsu, response number 6, knocked the door. At the sound of heavy knocks, Azizur Rahman got up and opened the door. Then, violating the norms, started assaulting Azizur Rahman mercilessly. The old man cried and pleaded with the Gatsu, saying that he did not know anything and was not part of the mob. In presence of his wife and daughter, the police officer kicked at in his ear and back of his head, and then he was dragged by police person to the police station at night. That was the allegation. They said they have approached the authority, but nothing has been done, no action has been taken. And they said in paragraph 9 specifically, they said that although magisterial inquiry was declared by the authority, but it was not properly done, as neither the person, namely Azizur Rahman Khan, Atabur Rahman Mazharbuya, YC Gatsu were questioned, nor the family members of the petitioner were summoned by the inquiry authority, and therefore no action has been taken against the persons from whom the father of the petitioner was tortured brutally, and he died in police custody. Even the family members of the petitioner was not aware of the said magisterial inquiry. So everything has been, they said the magisterial inquiry was done behind their back. I have here would like to indicate the magisterial inquiry report they have annexed at Annexure 2, page 19, it starts. And the list of persons who appeared in the magisterial inquiry is there at page 27. Serial number 3, statement of Rina Begum. Rina Begum is the daughter of the victim. So my submission is that in fact the family members were heard in the magisterial inquiry. The allegation is not correct. Again, in para 12, the same allegation has been made by them that the last sentence follows. During such inquiry, the magistrate shall allow the relatives of the deceased to remain present at the inquiry, but nothing has been done to take opinion of the petitioner's family. But I said that this is not correct because the daughter was heard. But in the writ petition, although this is the case projected, while arguing the case, in fact, during the proceeding of this writ petition, they have filed three the affidavits, two additional affidavits and one affidavit. The additional affidavit filed on 10/5/2023 at page 99. And the other affidavit is affidavit filed by the petitioner on 29/5/2025 at page 161. And the more additional affidavit filed by the petitioner on 4/6/2025 at page 171. Petition wherein a And then it to get up at the mean of nine, without nine, and then taken to the and interpreted as in such cases, see, under any economic situation or high blood pressure, and all these occurred to the same thing, and had it not been picked up in such a cruel manner, he could have definitely seen the next morning since he had own ailment and had also not having any criminal history. The opponent for the next is that due to the sudden death of the father, the entire family got several severe mental shock. So now, in one hand, they said that the police person has given a charge, twisted the head, twisted the neck, therefore he died. Here again they have said in paragraph 13 that syncope has happened because he was in a peaceful sleep. You have taken him suddenly. You have get the man up and taken up to the police station, and because of the excessive pulse, beat, heartbeat, high blood pressure, ultimately blood circulation to the brain has, and due to syncope he died. So two versions, in fact, from their side only they are saying two versions. So what I am trying to project is, this is the case, where the lordship will decide two things. One is, lordship. True. Therefore, what lordship will see in this type of cases, these are factual disputes, we are not on trial. These are factual disputes because only because in the writ petition projection is made different, in the additional affidavit projection is different. That is why I have to point it out. Ultimately, lordship will see whether this is infringement of fundamental right of the victim is there or not in the case, or this is a case of natural death. Police has admittedly taken him to the police station because at that point of time curfew was there, lot of disturbance was there in that particular place. Cases were there. Ultimately, for questioning him, he was taken to police station. It is an admitted thing, and the projection now that he was taken and suddenly twisting head, he was killed. That was a severe offense. That offense, whether lordship will see whether that offense has happened or not. That is otherwise lordship will see if the death is natural because of without any injury. Postmortem report, medical report doesn't suggest any injury. He died because of syncope and that was a natural death. Then lordship may not go to the CBI inquiry as has been prayed by them, and there will be no more of the action against the police officer as has been prayed by them. That is why I'm trying to take your lordship to that. So in the first affidavit, they have said that. In the second affidavit, lordship will kindly see at page 161. Additional affidavit. This is again an additional affidavit. This was filed on 29/5/2025. para 2. They said that the deponent begs to state that the father of the petitioner, that is the victim, late Lordship.
The PK Declaration Counsel for the petitioner is present. Submissions of Mr. Dina, the senior committee advocate, remains inconclusive. List as a parted matter on 12/3/2026.
Not so much. আপনার কই